Welcome back to Landlord Law TV. My name is Ben Reeve-Lewis. This is the lawyer Tessa Shepperson, whose brain we're going to be picking today. Special edition. We've come up to the studios in Norwich because there's big times going on. We've got new law coming in right now. A lot of things going on in housing generally. A lot of building work going on. A lot of building work going on out there a minute ago. It's been annoying us, and I had to go out and have a quiet word in that sort of direct charm that us people in South East London specialise in. But we're clear now, and we're going to be talking about the new law that's coming in, the Deregulation Act, 1st of October. All of the changes. There's a hell of a lot going on out there, making life quite difficult. A lot of things to get your head round with. So we've got an especially extended programme today, and we're going to be talking for a number of questions. We're going to be answering questions from a number of people about the changes that are in the pipeline, and hopefully really getting you on top of this kind of stuff. Now the first question, quite a short one, from Brian of Bournemouth, who says, I have smoke alarms on most of my properties, but I have one where I'm in a dispute with my tenant and he's refusing to let me in. How common is that? Am I likely to be prosecuted, says Brian.
Okay, well, first of all, we need to say that Brian is in Bournemouth.
Yes.
And that is significant.
Well done.
Because the regulations and the changes that we're going to be talking about are only effective in England. And this is the start of a bit of a sea change when there's going to be a divergence between the laws in England and the laws in Wales.
If you're a landlord in Wales, you've got your own third circle of hell to deal with.
So these things that we're going to be talking today will not be affecting landlords in Wales. It's only for properties in England. And the regulations are coming into force on the 1st of October. Now, the one we're talking about here is the one about smoke alarms. Now, basically what this says is that at the 1st of October, landlords need to have a smoke alarm on every storey of the property where there is living accommodation, and that includes things like a lavatory. And also in every room where there is a solid fuel fire, which means coal or wood, effectively, not gas or oil, you need to have a carbon monoxide alarm. And you need to have this as at the 1st of October. And it applies both to new tenancies and also to existing tenancies, which is why Brian's concerned about it, because there are sometimes problems that tenants won't let you in. Now, in this case, I don't think Brian needs to worry too much, because the legislation is quite specific, and it makes it clear that the local authorities do have the powers to so penalty notices, isn't it?
Yeah,
but the landlord will have a defence to this if he's tried to get in and the tenant won't let him. And the legislation specifically says that he doesn't have to bring legislation. So it's okay, landlords, you're not going to be expected to get an injunction or to go to court for a possession order. So I think Brian will be okay.
I think he will, but as an ex-enforcement officer, I would make sure you had something to confirm that you weren't letting in. Because it wouldn't wash if people said, well, they just wouldn't let me in. We'd want more than that.
So you need to have documented procedures.
Yeah.
So you need to write to the tenant, and you need to have a record that you've spoken to them and keep copies of conversations with them. And if you turn up there and they won't let you in, you need to keep a record of that on your file. And provided you've done that, and provided you've got a trail of documented evidence showing that you haven't been able to get in and that you've written to them and they haven't responded, then you should be okay. But you may need to prove that.
And what about the phenomenon of tenants removing batteries from these alarms every time they burn their sausages?
That's actually not going to be a problem. The landlord's responsibility is that the smoke alarms work on the first day of the tenancy. And it specifically says in the legislation the first day of the tenancy, or alternatively the 1st of October, for tenancies in existence at that time. So the government suggests that perhaps this is something that you do perhaps at the same time as you do the check-in and the inventory.
Yeah.
It needs to be done on the first day of the tenancy, even if the tenant's moving in later. However, after that, then the responsibility moves to the tenant. and it's the tenant's responsibility to maintain them and not the landlord's. So the landlord is not going to be blamed if the tenant wants to do bacon sandwiches and takes all the batteries out, because every time they do a bacon sandwich, they have to take their hearing aid out because they can't bear it. So, so Brian, you should be okay, but if you can, you should make sure that these things are fitted, and I would urge everybody to make sure that you do this.
One thing that occurs to me about the stories, and it says in the legislation that the ordinary meaning of a story should be applied to it. I don't want to overcomplicate it. But I know from a lot of old converted HMOs that I've been in, some of them kind of Victorian, some of them even Georgian, they're like rabbit warrens in there, and it's often difficult to tell what a story is.
Yes, I mean, I think it says in here that it is if there's living accommodation there.
That's the qualifier.
Yeah, and that includes bathrooms and lavatories. So, I mean, I would have thought from that if you had a level which just had a lavatory on it, you probably need to have
one there.
Just to be on the safe side. One of the good things is that they don't prescribe the type of alarm that you need. So it doesn't say whether it has to be batteries or mains. It's up for the landlord to select the one that he thinks, and also where you put it in the room as well. It's up to you, although, you know, perhaps take advice on this.
I've been into a lot of HMOs where they've had mains wired alarms and they can't turn them off, so the tenants put plastic bags over them with elastic bands.
Well, provided they're working on the first day,
then what else could you do?
And they've got evidence to show that they've done that, they should be okay.
This isn't HMO, so is it, because they've got their own legislation?
HMOs have got their own regulations. And it also doesn't apply for lodgers as well, and there are various other exemptions.
Right.
Okay.
There you go. That's one down, another few to go.
We'll be back in a few minutes.
Back in a minute. Our next topic, I know, is a topic of great importance to landlords, because we get more questions about that than anything else, which is the Section 21 changes under the Deregulation Act, the restrictions that are placed on when you can actually serve it or what would invalidate it.
Yeah.
Now, we've got a question from Sarah in Birmingham, but we'll hopefully go through these points. There's a couple of different limbs to this, isn't there? She says, I'm about to let out a property. I'm not going to take a deposit, and property is not an HMO. So the tenancy will be for 6 months. I want the property back after that time to live in myself. What do I need to do to ensure that I will be able to serve a valid Section 21?
Okay. Well, first of all, again, she's in Birmingham, so this is an English property. It's not a Welsh one. And she's
a lawyer's mind.
I know, yes. And she's going to be letting the property on or after the 1st of October, so these new regulations will apply to her. We don't have to worry about the deposit or the HMO, because that doesn't apply to this particular property. So let's go through the new requirements that you have to, the new boxes that you need to tick. Now, the first thing to say here, I suppose, is apart from one, they're not actually new requirements. They are things that landlords are supposed to have done anyway, but now the government is attaching these to the Section 21 procedure, so that the landlord cannot use the no-fault, notice-only procedure to evict their tenant unless they've done everything properly. So the first thing we need to look at is the energy performance certificate, and there's been a requirement to serve this for quite a long time, and generally I think it's supposed to be served really before the tenancy starts. But in this context, if you find that you've forgotten or for some reason it's been overlooked, you can serve it late, provided you do it before you serve your Section 21 notice. Now, it needn't necessarily be a new energy performance certificate. It just needs to be a valid one. So I think they last for 10 years, don't they?
Yeah.
Although you may want to have a new one done, because if you've done improvements that they make the property look more attractive. But you do need to serve the energy performance certificate. The next requirement, the next box to tick, is the gas safety certificate. And for a long time, landlords have been required for properties where there are gas appliances to have the property inspected before the tenants go in, and then annually by a gas installer who's registered with the gas safe register, and they need to give the certificate to the tenant. And so this is now being attached to the Section 21. Now, this will normally be a new tenancy, so there won't be a problem about gaining access, because when you let a property to a new tenant, a new tenancy starts, obviously there's going to be at least some void period before, so you will be able to get
that's the time to get it done.
And make sure that's done. And for both of these, you need to be able to prove that you've served them. So either get the tenant to initial and date a copy, or make sure you've got evidence that you've served these. So these are quite important.
I once went into an HMO and the landlord had sellotaped a blank one to the gas boiler and insisted that was serving. There was nothing written on it.
Probably wouldn't. Don't do that.
Yes, don't do that.
Don't do that. That's not going to help you. Now the next one is the interesting one, because this is the new requirement. And this is that you have to serve the government's How to Rent booklet. Now, I think actually this is quite a good idea in itself, in principle, because it's quite a good little booklet, and it has a lot of things in it that tenants need to know, because a lot of tenants, as we all know, a lot of tenants are, they don't know much about their rights and obligations.
Yeah. It's written in very simple language as well.
It's very nicely laid out, and it goes through, through the tenancy things at the beginning, things at the end. So I think it's a useful document for tenants to have. Of course, as always, the problem is in the detail. So you need to serve it at the beginning of the tenancy. It needs to be the current version. Now it's worth saying that this booklet, it's not going to be printed out, it's only available in electronic form. We'll give a link to where it is on the episode page for this episode of Landlord Law TV. So you need to make sure when you're serving it that it's the most recent one. So don't print out 5,000 copies and stockpile them for 5 years, because the government has told us that they are going to be regularly amending this. Interestingly, you can also serve it by email, so you can attach it to your email and serve it. So and that's the first time I think I've seen the government say in legislation that something can be served by email. So that's quite interesting. Yeah. Now you also need to reserve it when the tenancy is renewed. Now when you have a fixed term tenancy, the tenancy actually comes to an end at the end of the fixed term, and you will either have a new fixed term tenancy or a renewal form, or you will have a periodic tenancy. Now as we know from Superstrike, a periodic tenancy is actually a new tenancy, which is created under Section 5 of the Housing Act 1988. It's on the same terms and conditions as the preceding tenancy. So at that stage, you will need to serve the booklet again, but only if it's changed. So you'll need to check whether it's changed or not, and if it has, you'll need to serve it. I mean, if you've got a lot of properties, you might want to make it part of your procedure that you reserve it anyway. Just so you don't miss out. Again, when you're serving your Section 21 notice, if you find that you've forgotten to serve it, it does look from the regulations as if it will be all right if you serve it late, provided you serve it before you serve your Section 21 notice.
So it's not unlike the prescribed information for deposits. It's not a penalty, you don't get penalised for it.
Yes, now rather confusingly, in the regulations, it does refer to the How to Rent booklet as being prescribed information. Yeah. So that is going to be very confusing for people, because when you say prescribed information, you always think about the tenancy deposit, and as Ben says, that's got to be served within 30 days, otherwise you're in big problems. And this, although it's prescribed, but probably everybody's going to refer to it as the How to Rent booklet. Otherwise we're all going to get really confused about that. A couple of other things I want to mention. Firstly, that there is now a time limit. You can't serve Section 21 notices within the first 4 months of a new tenancy that starts after the 1st of October.
This will end decades-long practice amongst letting agents for serving you your notice the day you move in. Yeah,
that's right. Yes, you can't do that anymore. And I think it probably also means that when someone serves a Section 21 notice, it is most likely to be in a situation where the landlord genuinely is likely to want the property back.
Not just as a sword of Damocles over the tenant's head,
So, The other thing I want to say here is that Sarah says that she wants the property to live in herself. Now this means that the ground 1 mandatory ground for possession under Schedule 2 of the Housing Act 1988 is going to be open to Sarah and also to a lot of other people. Just to remind you about this, ground 1, it's sort of the owner-occupier ground, and you can use it either if you've lived in the property yourself before you rent it, so a typical example would be someone who's renting their own home when they're going abroad to work or moving to another part of the country, or maybe if they've letting it because they haven't been able to sell it and they've got another property. The other circumstance is if you want to live in it yourself or for your spouse or civil partner. Now, in those circumstances, to be able to use ground 1 as a mandatory ground, you need to have given the tenant notice of this, and the notice needs to be given to the tenant really not later than the start of the tenancy. So you either need to give the notice before, or most people actually put it in the tenancy agreement itself. And you need to...
So it doesn't have a sort of prescribed format?
There isn't a prescribed format for it. Okay. You just have to give notice. If you want to use this ground and you haven't given notice, the judge does have the power at the hearing to waive the requirement if he thinks it's just and equitable. But that means you going into proceedings not knowing whether you're going to succeed or not. So, you really want to serve that notice. So if you have lived in the property before, or it's likely that you're going to want it for your own use, then I would recommend that from now on, landlords and letting agents ensure that a ground 1 notice is inserted in their tenancy agreements.
Now that's a very significant change, a good piece of advice, that with the complexities of Section 21s, you might be best served using ground 1 from the start.
It may be
obviously
easier.
You wouldn't be able to do it if you were a buy-to-let landlord because you haven't been there.
Because you often, the
first limb of it,
Yeah, but it's something you need to consider.
That's an interesting one. I think it's also important to emphasise that housing advice teams, usually based in councils' homelessness units, they have homelessness prevention officers, and their job is to prevent homelessness. And one way to do that is to look at the paperwork and say these notices are invalid. Now, in the last few weeks I've been to Dorset, I've been to Somerset, next month I'm going to Cambridge, all training homelessness units in how to spot. They've asked for training on this. So when people go for the advice that they've got on the notice, then if it's not there, then you're going to be advising them what it is that they can do. So the other side of the industry is already getting very hot on this.
And it is something that and this is why it's so important that landlords are in a position to prove these things, because if the tenant does go to the homelessness department, they are going to require proof that they have.
Is there another element to the time limit as well? My memory serves me right, it's only 6 months long now, isn't it?
That's right, yes, there's a limit to the time that you can use the Section 21 notice after it's been served. It's 6 months or 4 months after if it's a periodic.
Right, okay.
So it's much more constrained. That's answered Sarah, so you need to be careful to do all these things, Sarah, and you need to make sure that you have documentary procedures. Okay, we'll see you back in a few minutes.
See you soon. Okay, and next point has been raised by Ian from Hampshire. It's a very, very common complaint or concern that he's got that I've heard a lot of landlords talk about. He's saying, I am about to let a property to a tenant under a 12-month fixed term AST. I will then want the property back as my daughter is getting married and I promised it to her and her husband. I'm concerned about the possibility that my tenant will try to prevent me getting my property back by making false accusations about its condition or even deliberately damaging it. What can I do to protect my position? He's obviously talking about retaliatory eviction here.
Yeah. Now I think I'll start off here by saying that when we were talking about Sarah's problem earlier, we said that she could serve a ground one notice.
Yeah.
Now this won't apply for Ian because he doesn't want it for himself, and presumably he hasn't lived in it himself, so he won't be able to use that. So he will be looking at section 21. Now we have brought in new retaliatory eviction rules. They will only apply, as do all these rules, for properties in England, for tenancies that start after the 1st of October. And this is basically, if a tenant makes a complaint about a property, then the landlord has to deal with it. I think it's within 14 days, and they have to go back to the tenant, and they need to say to the tenant what they're going to do and the time period in which they're going to do it, and they need to go back and do that within 14 days. Now, if after that the tenant goes to the local authority and the local authority serves a notice, then they can't serve a valid Section 21 notice for a period of 6 months. So, Ben, tell us about the local authority notices and how likely they are to actually serve them. Is this a real problem that landlords need to worry about?
Well, I've done extensive research simply because I've sat 10 foot from a bunch of environment health officers for the last few years. It's been a bit of a thorny issue right from the start, because I think Shelter raised the point of a certain amount of retaliatory evictions. The landlord community took the view for quite some time that they didn't have any hard evidence for it and that they didn't think it was as big a problem as would need legislation, but it's come through anyway through the Deregulation Act. And a lot of the concerns of landlords, I'm sure some people watching this now will think the same thing, is that what will happen is that their tenant will go into the council, make some spurious complaint, and the Environment Health Officer will serve a notice just to block the Section 21. But it's really not going to happen. I mean, the first thing to be aware of is that there's only 3 types of notice that's applicable. There are improvement notices for Category 1 and Category 2 hazards and emergency remedial work. There are a lot of other notices that an environmental health officer can serve, but they don't count in terms of blocking the Section 21.
As far as this is concerned.
Yeah, absolutely. You've also got the notion that if the Section 21 has already been served before the notice is served, then that won't cancel it out either. And the bottom line is, I find environmental health officers very kind of conscientious and detailed people, a bit like lawyers. They go for that kind of stuff, and they're not going to be forced into serving a notice because there's a broken light bulb or something like that.
Yeah.
So it's got to be really rigorously checked. It really will be. So I don't think the landlords need to worry too much about this, and the environmental health officers I've spoken to who would be charged with doing this have said that they don't see many occasions when they're going to get called out to do this, to be honest.
So they're only going to be serving the notice if it's a genuine situation of a landlord who the property really is in serious disrepair.
Absolutely. Environmental health officers are audited, and they wouldn't instigate some sort of legal action when they didn't have a basis for doing it.
Okay. Just looking at because Ian says he's concerned about the possibility to do that, and what can he do to protect his position.
Yeah.
So I just want to go over that a bit. What I would suggest you do is that you, in fact all landlords should do this, you need to be very careful that you are complying with all of your repairing obligations. So ideally you need to go in and do regular inspections of the property, and you need to document that you've done that.
How regularly would you say regular?
Probably, I think the normal one is quarterly. And you need to be careful, because obviously you don't want to go in every week, because the tenants will...
You can see where I'm going with this.
Tenants will feel that it's harassment. And, if you go into... a lot of tenants, they don't like the landlords going in and inspecting the property, which is fair enough. It is a bit of an intrusion. I think about quarterly is the normal, the normal that is done by, for example, letting agents. Perhaps half yearly, or even with some tenants yearly. But you need to go in regularly and have a look at it. Perhaps take someone with you if you're not a builder or somebody who's particularly knowledgeable about things. Perhaps take someone with you who would be able to spot if there's a problem, and then make sure that if anything is wrong, that you get it done. And then if a tenant does complain, you need to get onto it immediately and get it dealt with, even if it's not something serious. Even if it is, something that you think is silly.
Yeah.
Make sure that you respond to it and that you deal with it. But you need to document things. There's no point in doing it and not keeping a record of it. You've got to keep a record of everything. I mean, this is one of the problems about all these new regulations. It's going to mean a lot more record keeping.
Yeah.
So you need to have a file, you need to keep a record of all your telephone conversations, you need to keep a record of all your visits, you need to keep a record of what happened with your visits, and then after the visit it's probably a good idea to write to the tenant and say what happened, and then that will serve to corroborate the fact that you actually did the visit and that the work was done and that what you discussed. So you need to be careful to do all of that.
I think that's quite important in the early stages of it as well, because if I remember rightly, section 33 that covers this says that when the tenant tries to contact you, you have to say what work you're going to do, a time scale.
Well, that's the first bit, that when the tenant complains, you need to respond within 14 days. Now, interestingly, the inability to serve a section 21 notice is solely based on the local authority notice.
Yeah.
But if you don't respond, it looks as if technically you can still serve the section 21 notice even if you don't comply with the responding within 14 days. But of course you are always at risk of the local authority then coming in and serving a notice, in which case if they had complained before you served your section 21 notice, then your notice would be invalid.
Yeah.
So you do need to be careful about that.
Most environment health officers I know, particularly in cities, if they get a complaint in, and it's going to be 2 or 3 weeks before they can diarise it and actually get out to do it. So the landlord's still got a lot more time to do it.
Okay, well I think that's probably more or less what we want to talk about this. One other thing I would say is that in our episode 2 in series 1 we did have a really good interview with Rajiv Nayak of Fixed Flow. So if this is something that concerns you, I would suggest you go and watch that episode and watch Rajiv's interview, because he goes into a lot more detail about some of the aspects that we haven't discussed today. So watch it, go back and have a look at that. And so far as Ian is concerned, make sure that you keep records of everything you do and respond to everything completely and promptly.
That's becoming an important point on all of this.
All of this, record keeping.
Yeah.
Okay, we'll be back in a few minutes.
Okay, our last topic is a subject that a lot of landlords are concerned with. It's a very short question, but having about the Section 21 form and having had a look at it, I don't think it's going to be a short answer. So the question is from Sam in Southampton. I understand there's going to be a new prescribed form of Section 21. Do I need to use this for all my properties or just those that start after the 1st of October 2015?
Okay, well yes, there is going to be a new form. First of all, it's only going to be for English properties, as is all this legislation. And you only need to use it for properties that start after the 1st of October. Now effectively that means, we're filming this right at the end of September. If a property starts on the 1st of October, the regulations say that you can't serve a Section 21 notice during the first 4 months. So we won't need to use this notice until February, really.
So we're not,
So the government, I have to say, have published these regulations, and this notice has been redrafted several times. And it is a little bit close to the wire because it's only been published, it hadn't, at the time we're recording this, it hasn't officially been published, although we've got what we think is the final version here.
What we think is the final
version. But as I said, nobody's going to use it really until February. So you don't have to use it apart from those ones. Now, interestingly, the form says that you can use it for earlier tenancies, but we would suggest that you don't. because the form is preceded by a lot of bullet points, which we're going to go over in a minute, which set out all the law relating to the new Section 21 regulations. And if you serve this in respect of an earlier tenancy where they don't apply, you're going to confuse your tenant.
Yeah.
Because they're going to say, hang on a minute, what's all this? My landlord hasn't done that. And then you'll go and say, well, actually, I don't have to. And they're going to look very suspiciously at you.
Yeah.
So I would suggest that you only use this notice for tenancies that actually started new on or after.
So the earliest one we're going to see is 1st of February.
Yeah. So don't do that. Now, that doesn't mean to say that there isn't going to be a change for Section 21 notices. Everybody's going to be really pleased about this. It's something people have been asking for ages. The new Section 21, what is it? It's 4Z, I think. Yeah, 4ZA says that in the case of a dwelling house in England, subsection 4A has the effect with the omission of the requirement for the date specified in the notice to be the last day of a period of the tenancy.
Now that was always the thing that made the wheels come off.
That's right, yes. Yeah. So I don't think anybody will be sad to see the last of that. Unfortunately, it's still going to be there for Welsh landlords, so sorry about that, Welsh landlords. Yeah. But for English landlords...
There's one getting on his bike now.
Absolutely, yes. So for English landlords, you won't have to worry about that anymore. And I'm going to have to be redrafting my Section 21 notice to change the saving clause that I have in it. Let's just have a quick look at this notice that we've got here. And one thing I will say, actually, having mentioned saving clauses, is that it doesn't have a saving clause in it. That is perhaps a little bit unfortunate, so you are going to have to be careful about your notice. But not having a saving clause won't be quite as crucial as it was when we had the last day of a period of the tenancy wording, because the actual day that the notice expires is not critical anymore.
Yeah.
So
other than the fact it's got to be 2 months, isn't it? That's
other than the fact that you mustn't give a short notice period.
Yeah.
So the most important thing is giving enough notice, really, making sure that you give enough notice to the tenant. And when you do that, you have to remember that you have to serve the notice. And sometimes when you serve a notice, there is a deemed service period, and you've got to take account of that. So if you serve it by post, which incidentally is not something I would recommend in most things, but if you do, then there's a deemed service period of about 2 days.
The amount of cases I've defended in court where the tenant has said, I've never seen this document.
Yeah, and how can you prove it?
The dog ate it.
How can you prove it if you've just put it in the post?
Exactly.
So you really need to actually have a copy that's signed by the tenant as received, or you need to have evidence of an independent witness that you've put it through the letterbox or use a process server. So this notice that we've got here, one of the good things about having a prescribed form is that if you use the form and you fill it out properly and you've got your notice period correct, there can't be any arguments about the form. I mean, it's noticeable with the earlier legislation. There were so many cases about Section 21 notices being wrong, hardly any cases about the Section 8 notices being wrong.
Yep.
And that was because there was a prescribed form. And I know that's why a lot of us, when we were at meetings with the government, we said, you've got to have a prescribed form for Section 21 because it cut out all these errors.
Well, as we were discussing earlier, if you look at Section 21 in its original form in the 88 Act, it doesn't even mention it has to be in writing.
I know. And now we've got the prescribed form. Might quickly mention that I understand that there is going to be a slight change in the Section 8 notice as well.
Oh, sure.
So landlords need to, in England, so we need to, but we're talking about Section 21 here. So the notice starts off with having a lot of bullet points with things like write clearly in black ink and that sort of thing. And it sets out all the things that we've been talking about earlier in this programme, which is about the fact that you can't serve it during the first 4 months, that the retaliatory eviction thing, energy performance, gas certificate, how to rent, and also the existing rules that you have to comply with, which is about tenancy deposit protection, and for HMO properties which require a licence, you can't serve it while the property is unlicensed. Although interestingly, you can if you've applied for a licence, and of course also if you've got a temporary exemption notice.
Which environmental health officers, in my experience, are usually more than happy to grant.
Although they can only do it for 3 months at a time, so it's not a total answer. It then says landlords who are unsure should seek specialist legal advice, so I think there will be a lot of people having advice with this. And then the form goes on to say, again, that it must only be used for It must be used for post 1st of October, but it can be used for earlier ones. So as I said, we don't think you
Not
should do that.
Yeah.
There's some helpful notes on it at the bottom of the first page, and then it goes on to say in paragraph 3 specifically that it's valid for 6 months only, unless you've got a periodic tenancy, in which case it's valid for 4 months from the date in the notice.
Right.
Okay, so there's a difference there.
That's a significant thing, isn't it? Because that whole notion addresses the routine serving of Section 21. So now a landlord should really only be serving it if they're intending to go for possession.
Yeah, I mean, in the past, it's often been quite standard for a landlord to serve a Section 21 notice.
The day you move in, letting agents particularly.
Yeah, the day you move in. Of course, you've got to comply with the tenancy deposit regulations, but you won't be able to do that now. For a start, you can't serve it during the first 4 months. That's probably why they put that in. And there's also this limited period of time in which you can use it. So that. And then at the end of the notice, there are some points that you've got here. First of all, there's a point saying you have to read it carefully, but obviously you should, and then it talks about the notice period. Another interesting point here is about the rent, and it's basically that if you've paid rent in advance and you leave because of this notice before the period that you're paid up to,
right,
the landlord has to refund that money, basically. I mean, there's quite a complicated calculation set up in the regulations, but I think basically...
You surprised me.
I think basically you have to refund them for the period that they've paid in advance, so they're not overpaying. And then right at the end, there's some wording which you were saying earlier, Ben, is very similar to the old standard wording that had to go on notices to quit, which is that if you're a tenant and you get this notice, you should take advice. And if you are a tenant watching this, that's good advice. You should take advice because these are complicated regulations. The landlords have got a lot of hoops to jump through. So you may. It may be that you don't actually have to leave to go and the landlord's got things wrong, so do check things out. And also, if you are a homelessness advisor, you need to check all these things as well.
Exactly, yeah. So there you are. The job of being a landlord just got a hell of a lot harder than it was a short time ago. You've got all these different hoops you've got to jump through. There are things you've got to do at the start of the tenancy, things you've got to do at the end of the tenancy, and things you've got to do throughout the life of the tenancy. The net is closing quite tight on all of this. Difficult job being a landlord. Perhaps the only winners of all this are lawyers and housing law training companies. And the crowd.
I think also it's worth saying that probably this is the start of the end of the amateur landlord.
Yeah, absolutely, yeah.
If you are letting a property and you haven't really got a clue about housing law, you've got to struggle. It's a very dangerous thing to do. Yeah. So I would recommend that either you get trained for housing law or you use a decent agent. Yeah. Because it's not really possible, I think, for people just to let a property knowing nothing about the regulations. And that's it. So we'll see you again next time. And something more cheerful. We'll see you then.